I think there's changes coming through are going to be the end of the moratorium on possession proceedings. There's going to be an avalanche of litigation, both residential and especially commercial landlord and tenant, to catch up with unfinished business under the pandemic. So I anticipate immense changes in the law on frustration of contracts, especially with so many tenants trying to say, we had a short tenancy agreement, but my ability to make use of the property I took a license or a tenancy agreement on was completely frustrated by the pandemic. Not only that, it was made unlawful for me to use it in the way I envisaged it under the terms of the contract and planning permission, because the government said if I go in I'll be prosecuted. And the landlords are saying, well, you contracted with us. So there's a big tension there, and there's a lot of that going to be coming through. I haven't seen the big cases yet, but I anticipate them. That's the law of frustration. And there's going to be some interesting repercussions on the massive changes to what's called permitted development in planning. Until the pandemic, local authorities were very jealous in guarding different categories of what they call user, which you might translate as use, of different properties: residential, office, retail, industrial. But the pandemic has brought forward and accelerated changes which are already underway in office and retail. So retail has gone to Amazon and online platforms. Office has gone to Zoom and home working. Consequently, there's a massive oversupply of retail and office property. And this fits in with the fact that, take America for example, there's 10 times the real estate devoted to retail as there is in Germany. And in the UK we have 5 times what they have in Germany. And a lot of that is simply redundant space in the present age, especially as we may or may not be going to a recession. So the government last summer brought in some revolutionary changes which said if your property remains vacant for 3 months, you can shift it over to residential as permitted user without making any planning application. So that's going to have the effect, if you've got a difficult tenant who's struggling in the pandemic, ease them out by whatever means possible, leave it open for 3 months and then turn it into flats. So I think that's going to generate some litigation as to the manner and lawfulness of the means they're using to ease out bad tenants. And there's also a lot of passing the parcel for the losses of the pandemic in the property world, and a lot of it's going to implode.